An ounce of prevention in contract drafting is worth a pound of cure in litigation. By embedding clear conflict management mechanisms, you significantly reduce the risk of expensive, public, nasty, protracted litigation. We want to ensure that when disagreements arise, and being an attorney, I'll tell you, disagreements arise all the time. There should be a clear, cost effective path to resolution that protects your business. Personally, I like to use a multi tiered approach. In any core business contract that my office puts together, we typically outline how disagreements will be handled in three steps or three phases. The first is initial good faith negotiations. Have the parties just sit down and meet and attempt to resolve the issue directly. Put a time frame on it, but let's say, hey, let's just sit down like rational adults and see if we can work this out before we go spend a bunch of time and money with attorneys and try to resolve our issues on our own. If that fails, then the next thing I'll typically put in the contract is mandatory mediation. So, this is where the parties agree to hire a neutral third party mediator to try to facilitate a settlement. In my experience, if everyone is committed to reaching a business resolution and not just trying to stab each other in the back and prove who was wrong and who was the worst person, the mediation can often resolve the vast majority of business disputes confidentially and quickly, which means it also saves you money. As a last resort, then we can look at arbitration or litigation. The truth is that either option is incredibly expensive, it's time consuming, it will distract you from your business, and the truth is no one really wins except the attorneys. We also want to make sure that your key contracts have some key jurisdictional and procedural clauses. So the choice of law provision that almost no one ever looks at, this is the clause that specifies the jurisdiction whose laws will govern how we interpret the contract and how the contract is enforced. All too often, I'll see clients sign a contract that says it's governed by the law of random state X that they're not really in, they're not doing business in, and they don't know what laws are going to apply in that situation. The other one is your jurisdiction or arbitration clause. This determines exactly which forum we're going to go to if there is a dispute. So if we've gone through negotiations, we've gone through mediation, where do we turn to next? Oftentimes, this is the clause that says the state and federal courts in Columbus, Ohio, or Franklin County, Ohio, shall have exclusive jurisdiction. An arbitration clause is very similar, it just mandates that the process goes through arbitration, which some people argue is faster and cheaper than going through litigation in court. So here you might see any dispute arising under this contract shall be submitted to binding arbitration in accordance with the rules of the American Arbitration Association or some other arbitration body. So we've covered the complexity of standardizing client agreements, structuring those strategic partnerships, and embedding proactive dispute resolution. All of this points to one undeniable truth. Legal diligence is not a one-time event. It's an ongoing strategic process. The moment you stop evolving your legal strategy is the moment you expose your business to unnecessary risk.